Okay, well, we are ready to roll with the first panel, which, as you see from your agenda, is going to address Washington water issues generally. And let me introduce our panel, the first panel of the day, which is going to run till about 10 o'clock, and then we'll have a break. You've already met Justice Deborah Stevens, who was appointed to, or elected to, the Washington Supreme Court in January of 2008. Prior to that, she was at Division III of the Court of Appeals here in Spokane. She's had many appellate cases in state and federal courts over the course of her career in Washington, Idaho. For sure, she was an adjunct professor at Gonzaga Law School and Gonzaga a grad for both undergraduate and law school. So she's well prepared to discuss the water issues today. Judge Carol Murphy is the presiding judge of Thurston County Superior Court, which you heard is the seat of government, Superior Court in Olympia. But of course, because she's in Superior Court, she's also doing a lot of civil matters and criminal matters and everything else that moves through the Superior Courts. She was elected in 2008 for the first time, and again in 2013, and occasionally does water rights cases. And she was an assistant attorney general for many years, and I had the honor of working with Judge Murphy. Next is Maya Bellin. Maya is the agency director of the state agency in this state called the Department of Ecology that manages water resources along with many other programs that an environmental regulatory agency would handle. Maya is of Native American descent, Mescalero Apache. She's the first Native American agency, executive cabinet agency head in Washington State. Before being the agency director, she managed the water resources program of the Department of Ecology. She also served many years as an assistant attorney general with the division that represented the Department of Ecology and did many water rights cases as an assistant attorney general. And last but not least, of course, is our colleague Tom McDonald. Tom is now a partner with Cascadia Law Firm in Olympia. Prior to that, he was my colleague on the adjudicatory boards and chair of the Pollution Control Hearings Board for several years, handling water rights matters. Tom has worked for both Colorado and Washington Attorney General's office, but he's been always focused on water law. He's been an adjunct professor of water law at Seattle University, and he was the co-author of a book that I kept very close to my desk when I was on the board. It's the Introduction to Washington Water Law, and we called it, "Where's the Blue Book? I need the Blue Book to figure this case out." So that's our morning panel. And what we have decided to do for starters here is Tom is going to do a brief overview of the nature of water rights adjudication in Washington, just to ground you, and then Ms. Bellin is going to discuss strategies that the water agency, the Department of Ecology, is using in this state. So we're going to have two 10-minute introductory comments before we turn to the panel discussion. So I'm going to turn it over to Tom first, who will talk, and he has some written materials in the notebooks that you can follow along with. So, Tom?
Thank you, Kathy. Obviously an honor to be here, and despite what Kathy said in her earlier comments, I am nervous. I'm looking out at many of the justices and the people I look up to and my mentors, and people who wrote some of the books I used in my law school class, and so I'm hopefully will do justice to what I'm supposed to do here for you. Our panel was thinking about when we were going to present the Washington, kind of what's going on in Washington water law in terms of water rights adjudication, that we make sure we set the stage as to what the issues are and what the issues are presented to to the Department of Ecology and the courts. Every state is unique. Like Kathy said, I worked in Colorado, I did some work in Arizona, I've done some work in Oregon, and every place I've gone, it's unique. And coming from Colorado Attorney General's office to the Washington State Attorney General's office, it was a stark contrast in terms of how things are done. And so I thought it was a good idea to kind of just set the stage as to why we have the issues we have in this state, which are very complex, and why it's so difficult for, I would say difficult, for Director Bellin and running the water resources, running the agency, but in terms of water resources, in the state, as well as then how it gets presented to the courts and the difficulty I think they have in going through these cases. And for me, back in private practice, it just goes back to having fun again, trying to poke the law a little bit and see where we can go with it. I want to first review just kind of where we are in the water law system in this state, and then kind of go through the adjudicative process that we have here. This state started out as riparian. And then it became a dual state, riparian prior appropriation. It had some territorial laws that tried to push it towards a prior appropriation, but still protect the riparian water rights. Then in 1917, the legislature put together what they called the most comprehensive water resources statute. And in fact, stated how impressed they were because they were using much of what the other states had already done. Many of the other states had already passed comprehensive water resource legislation. What they did is they essentially established this state as a prior appropriative state. What they also did, though, is they said that all other, which is logical, all water rights up to 1917 that have been established are to remain protected, and they're not to be affected at all by this law, not necessarily not be affected by it, but those rights remain valid. Well, of course, what they were doing was they were validating not only the appropriative rights, which ran under the guise of and the conditions of a prior appropriative right, but they were also doing it for riparian water rights, which obviously have different elements to them other than the prior appropriative rights, such as you don't have to put the water necessarily to beneficial use in order to maintain that water right. But what the intent, I think, was of the 1917 code, well, what two things the 1917 code did was they set forth an adjudicative process that is to go through the superior courts, which is our trial court of general jurisdiction, which I know in Colorado and I think in Idaho it's called the district court. Here it's a superior court. And set through that whole process. And then it said from now on, from 1917 on, all new water rights are to be permitted under a permit system. So that's what we started getting. We started getting, the permits started issued after 1917 for new water rights. And adjudications did begin. And about between 1917 and probably 1970 or so, only about 10% of the state got adjudicated. So I don't think it really met the intent of the 1917 Water Code, which was to, I think, say, let's firm all the water rights up that we have, the common law water rights, and then from now on, then we'll have the permit system. Well, we only got 10% of the adjudicative, of these water rights adjudicated. Part of the problem was, doing some research on it, was the cost of doing it. It was to be, the cost was to be put on to the water right holders, and a lot of times they just couldn't afford it. And the other thing was World War II really stopped everything, and it never got started again very well. So, in 1970, then we started the Aquavella adjudication. And that's supposed to be another 10% of the state will be adjudicated. Of course, Aquavella is not adjudicating groundwater, so there's still that question there. But so we have, after Aquavella, which should be wrapped up soon, optimistically, we'll have 80% of the state not adjudicated yet. And so between 1917 and 1984, which becomes a key date, we had all kinds of fights still occurring between the riparian water rights and the prior appropriative water rights. as to who had the superior right. And eventually the courts were having to handle this, and they were saying, okay, the riparian water rights have to fall within this idea of beneficial use and due diligence, because that's what the law is now. But they never really told the riparian water rights what that meant. They only did it on factual cases. Well, in 1984, in the Abbott case, the Supreme Court finally said, all you riparian water rights, common law riparian water rights, diversionary water rights, you should have put your water to use by 1932. So in 1984, we're telling you, you should have had your water rights put to use by 1932, or they're gone. So in that sense, we now have this law that if you didn't use your water by 1932, your water rights were gone. That really didn't, though, answer the question of what are those water rights, where are they, because we're not doing the adjudications. So in 1969, the state passed the registration law, which was everybody who doesn't have a permit or certificate issued under the permit process, or doesn't have adjudicative water right, which is only 10% of the state, you have to come in and file a form that tells us you think you have a water right. And most of these obviously are based upon the pre-1917 common law water rights. So a mass effort went out, and all these forms, hundreds of thousands of forms came in saying, we think we have a water right, from the groundwater use of 10 gallons per minute for a home to the large operations, thousands of CFS. They filed these forms. That didn't give them a water right by filing the form. All it did was protect whatever water right they had. If you didn't file the form, you have no water right. Of course, this law kept getting amended at least 3 or 4 times up through the 1980s, because people were all of a sudden finding out, oh, I didn't file my form. So they went to the legislature and said, you have to reopen that registration act so we can file our form. And the legislature did 3 or 4 times, but they were in the bind of, this water right kind of got canceled legally by our old other statute, so we'll open it up again, but your priority date is no longer what you thought it was, 1880 or 1910. It's now the date that we passed this law. So they lost 100 years sometimes of their priority date. So that gets complicated. So they have all these forms, and so the Department of Ecology obviously has the enforcement action to protect senior water rights, and they did try to do that with water rights that were represented by these claims, riparian water rights in an area called Sinking Creek, very close to here, Spokane. I was on that case. It was a fascinating case. We went through and determined, yes, these folks have riparian water rights. These claims they filed protected them, and we are going to enforce against the groundwater rights up above, who were pulling out the groundwater, affecting the flow of the river. One of the first kind of cases on hydraulic continuity also. And the Supreme Court reversed our decision in terms of the Department of Ecology's authority to regulate the permitted groundwater rights, because in so doing, the ecology was adjudicating the water rights represented by claims, and only the Superior Court can adjudicate water rights, and therefore those claims can't be protected by the Department of Ecology. What that does is that really puts them in a position of not able not only to protect them, not having problems with trying to transfer them, and so I think we're going to get into that a little bit more. But that's kind of the stage on that. In 1970, the Department of Ecology was formed. It was formed as one of the super agencies, and coming into the Department of Ecology were the other agencies, including the Department of Water Resources, which was prior to the Department of Ecology. And at that same time, the Pollution Control Hearings Board was created. And that's the time that the legislature took away from the superior courts the adjudicative process of not doing a general stream adjudication. The superior courts only can do that. But the adjudication between the fights between the individual water rights and the enforcement, appeals of any decisions by the Department of Water Resources, those were appealed directly to the Superior Court. the legislature took that away and gave that to the Pollution Control Hearings Board, a 3-member board, that said, you now will be the trial court, basically. You will decide essentially appeals of any of the Department of Ecology's enforcement decisions and permitting decisions. And I'll get into the adjudicative process there in a minute. The other thing is that then the state also created minimum midstream flows after that. And that was brought up a little bit last night. And so we have minimum flows now that are set by rule. And these are, and the priority date is the date that the rule is promulgated. So every water right that is issued, every application, it should say, that is filed after those dates, after the date of the in-stream flow, is going to be subject to the in-stream flow, the minimum in-stream flow. Obviously, those are very junior water rights. But it brings into question enforcement actions, again, when you have a lot of these water rights that are non-adjudicated and are affecting the in-stream flows. So I'm running out of time, but I just want to let you know that the process now is for we still have the adjudicative process on general stream adjudication to go through the Superior Court. What we have in terms of just the permitting process, the appeals of the permitting process, the enforcement actions being taken, those go to the Pollution Control Hearings Board. They run it as a trial court. They are an agency, though, so they're also governed by the Administrative Procedures Act, but they generally follow the Superior Court Rules of Evidence, the Superior Court Rules of Procedure, Civil Procedure, and they make the decision on the case. Those then can be appealed to the Superior Court, and the Superior Court will act as an appellate court. In the material I provided you, it's on legal issues, it's going to be de novo review. On factual determinations, it's going to be substantial evidence. And that's how the Superior Court will look at it. The legislature, knowing that these will usually go to the appellate level, have provided for an opportunity for appellants to skip the Superior Court and go right to the Court of Appeals. The legislature has also provided for the opportunity for parties who are in the Court of Appeals to jump over the Court of Appeals and go right to Supreme Court. So we've actually had cases that have gone from the Pollution Control Hearings Board directly to the Supreme Court. They've gone directly to the Court of Appeals, but most of them go first through the Superior Court. So I think I've got to end, but we'll be talking about the issues. But that's kind of the playing field. We have a lot of unadjudicated water rights. We have a lot of common law water rights that ecology can't enforce or protect right now, unless we do the adjudication. We have minimum in-stream flows, and I think I should end, because I'm over my 10 minutes.
Good morning, everyone. I'm Maya Bellin. I'm the director of the Washington State Department of Ecology, and after hearing Tom McDonald's presentation, I asked myself, why do I keep doing this job? Why have I gotten pulled into this water resources world? Part of it is the challenges are so incredible, so large, so huge, that it's kind of a moth to a flame. We need to try to figure out how to work through these issues. Thank you, Your Honor. It's wonderful getting a judge to provide me water. I did that on purpose just to see. No. So you're seeing a very complex situation we have in the state of Washington, probably very similar to what is happening in many of your states, maybe not so similar in terms of how we've ultimately done our implementation of our program over the last 100 years since our Washington Water Code was adopted. So what I wanted to tell you about is just give you a quick high-level picture for the person who is getting the calls from the newlyweds in Skagit County saying that 5 years ago their parents bought them a lot that they presumed they would be able to build their family home on, and now we have an in-stream flow rule that says we've got problems with the levels of the streams, and therefore we need to be very careful about the out-of-stream uses in that system. And we have since found that groundwater is in hydraulic continuity with a salmon-bearing stream that has endangered species on it, because I get the calls from the Yakima Nation, which is an 1855 treaty right tribe here in the Central Valley of Washington, saying, wait a minute, you're handing out some water rights to some agricultural uses, and we have had our Washington Supreme Court find that we have a time immemorial right to the in-stream flow to protect our 1855 treaty right to take fish, because I'm the one who gets the calls from the shellfish growers that are saying, what's going on upstream with water, because it's not bringing down the freshet we need, continue to have a healthy shellfish bed in the Puget Sound, or up in one of our bays or in the Hood Canal. I'm the one who's getting calls from the city of Walla Walla, concerned about not having a backup water need because the Walla Walla River is flowing low. They happen to rely on surface water. I'm the one getting the calls from the city of Airway Heights, just right side out of town here, that we've discovered has an aquifer that is in a very concave, upside down situation, and we're losing 15 to 20 to 30 feet a year in depletion of an aquifer that does not recharge in a timely fashion because it's in one of the parts of our state where we don't get a lot of rainfall. And so I'm getting those calls every day, my staff, and trying to figure out how I manage this complicated water box that I've been put in. And actually some days it feels like a thimble in terms of my ability to answer that tug and pull between in-stream flow needs and our fish rights and the claims of 29 federally recognized tribes that either have treaties with the United States of America or they have executive orders with United States presidents saying that they're entitled to take fish and that they reserved their rights to do so, not borrow them back. They reserved those rights when they gave up other portions of their claims, including land base. And then on the other hand, we have 7 million people in Washington state. Our population is growing exponentially. I believe we are seeing climate migration to the state of Washington. Our friends from California, some of you I see here today, I know are looking at homes right now up in some of the wetter parts of our state, thinking about moving up north so that you don't have to be so concerned about whether you get to brush your teeth in the morning. So these are these complicated issues, and so how do we work around the situation? How do we provide those needs, and how do we strike that balance? We are essentially running a real estate commodity market. So even though our laws say that Washington waters are to be held in trust for the public, they're shared waters of Washingtonians. Once a claim has been filed, once a permit or certificate has been issued, and that water has been used and put to land and applied to land and become a usufruct, it is now an interest in real property. And when that is the scheme, I, as a water manager, have very minimal tools in terms of how to decide what water goes out the door, what water stays in the river and the aquifers, and to what beneficial use. I was once asked, if you could start this all over again, how would you do it? So I said, okay, 1492. Just a little maybe inside family joke, I apologize. I think before we had major development, I would have loved to have some of the incredible hydrogeologists that many of you see testify in front of you and in your boards, and that you see the records of when you're hearing these cases, look at and understand fully the relationship between ground and surface water in each of our watersheds. We've got 62 watersheds here in Washington. And then I would say, how much water can we take off of the top of these surface water systems? And how much water can be taken out of the groundwater to continue to make sure that that aquifer is sustainable and recharging? And then know what our portfolio is. And then make decisions based on the highest beneficial use, the best use of that water in a proportional way for that watershed to be able to use that water, but not essentially make it an ownership or a property right. Because then if that changes, and that is now not that activity, the most important and beneficial use of the water, then we can say it goes to the next more beneficial use of water. And trust me, we are in the most historic drought we've ever seen in the state of Washington, and my brothers and sisters in California would say, really? Because you're at 4 years into it, we're just 1 year into it. Very catastrophic situation. We're still at 68% extreme drought on all of the east side, and severe drought on the west side. We had no snowpack to be able to replenish our waters, our rivers and our streams last year, and that aquifer relationship engagement that occurs to fill our reservoirs. That has put a very fine point on what is the highest need and most beneficial use. And that dialogue is very robust right now in terms of me getting called questions. How come a wheat farmer gets to use this water while an orchard of pears or cherries that may on the market have a much higher value, why are they having to go dry? And by the way, it'll take 8 to 10 years when those trees dry for them to replant that crop and build up a robust cherry farm again versus the year-to-year annual crop lower wielding market value situation. I don't get to cast judgment on that, and maybe it's good for my marriage and my personal life because that's stressful decision making. I have to say, first in time, first in right, prior appropriation. If you're adjudicated, much better for you. That's the next best option, to be in an adjudicated basin where we know who are the haves and the have-nots. And then in other areas, we're doing our best kind of on a permit-by-permit basis to make sure we're understanding what our water supply is and how to be able to put that out there and understand how to protect that in light of in-stream flows, which is our in-stream flow rulemaking process that we have, which is another layer of, if we haven't adjudicated, it's kind of our short of an adjudication. We make a blessing on a water river system and say this much water needs to stay in the system to be able to support in-stream habitat, in-stream needs, to support our fish needs. But those are litigated and very controversial because they're quite not an adjudication, and many feel that we aren't making the best decisions in terms of a lot of our communities saying that water is there for us to take. If I see the water running down that river, it should mean that I could put a straw in there and take that. And there should be, and I always get the people versus fish. Does the state think fish are more important than people? And always trying to make sure that we work through that issue. So I'm happy to be here today to be able to talk to you about some of these complexities. My strategies are getting in-stream flow rules adopted and trying to manage those to keep some water in the river if it's not an adjudicated basin. We're still wrapping up a 35-year-long adjudication in the Yakima. The Spokane area has been asked to be adjudicated, petitioned many times. We're talking 4, 5, 6 times more the amount of claimants, and our Yakima adjudication has taken 35 years. I did put an in-stream flow rule and adopted one on the Spokane River because my friend, Judge Wildman, has been making some decisions on the water that's coming in from Idaho that we're so graciously sharing with Idaho right now, to say we'd like a little bit of that water to stay in the system, but adjudicating that's $50 million, $60 million. When you get that done, we'll have you come over and help us out as well. And then what we've done, so we've tried to say, how do we deal with this box? Many of you have relinquishment concepts. We have a disincentive for people to conserve water because we've set up this real estate system, and if you don't use it, you lose it, and on and on and on. Our state set up a water law called the Trust Water Law. Mr. McDonald advised us on how to draft some of that language that takes away the disincentive. If you are a farmer and you have 100 acres, you're only going to use 50 for the next 10 years. In our state, a 5-year use it or lose it. You would only get 50 by the end of your 10 years. If you think you might use that other 50%, instead of losing it, put it in our state trust program where we park it and we decide what uses it can go to. And a lot of that is to stay in stream because we're already in bad shape, over appropriated and depleted in many times. So that's a system we're trying to mature and get farmers and senior water right holders used to using. But we're also just having to do different things like shake people's hands. Many of you may have heard about the Yakima Integrated Plan. It is an incredibly complex plan to help us deal with water management in the Yakima Basin for the next 50 years, and a big piece of that is to be able to deal with our huge agricultural economy, but also the growth, the needs of humans and communities and hospitals and schools, and then the rural development where there's, permit exempt needs as well, those smaller groundwater wells that aren't necessarily part of the bigger structure. We have had farmers who have senior water rights, 1880, 1899, 1900, that could just say, why do I need to deal with the juniors? Why should I care about what happens to the next person in line? I've got mine, my great-great-greats staked claims here, and we should be the haves. We have irrigators that understand that they live in communities too, and that their neighbors and the folks that they're living around have needs too. And voluntarily, many senior water right holders during this drought this year in Yakima, who could have used every drop of their water right, chose to voluntarily not use their full amount, to let that go to the next person in line. And so those are some of the incredible engagements that we're having when we realize if we just stick in this legal thimble, things aren't going to go well for us as a community. But if we can shake hands, and why this agreement worked so well, the Yakima Nation, who has an in-stream flow right for the time immemorial right to keep water in the system for their fishery right, was at the table, and their needs and their interests were heard. The huge senior irrigators were at the table. Community members, local governments, stakeholders from all kinds of areas, the Fish and Wildlife, the Federal Fish and Wildlife, the Army Corps of Engineers, the U.S. Bureau of Reclamation. So that's going to be our future in terms of where we really have success in the long run, because right now the legal thimble is very small in terms of how we manage the system, and we need to find other ways to be able to think about the future needs in Washington State. And I did see a hand from Nevada. Yes.
I'm floored that the first hour I'm here, I've heard like 8 issues that we're dealing with in our state. So, 2 quick questions. How are you funding adjudications?
Then you pass around the cup.
Understand that problem?
So yeah, our legislature provides the funding for the state and our Superior Court needs, because our Superior Court is our adjudicator. I think we've spent about $35 million to date, and so that's why me going back to Washington State Legislature saying, man, we really need to adjudicate the Spokane River, eyes get glassed over, and my state is looking at other huge revenue issues in us coming out of this recession, so there's not a great reception in terms of that, but our state legislature from general funds, from general taxpayer dollars is what's been paying for adjudications.
Under Nevada, take a few zeros off that. I'm really interested in this trust program to protect your water and support forfeiture, because that's a discussion in Nevada on use it or lose it doesn't concern. Was that a legislatively set up program?
Yes, yes. Tom, was it agency request from us? Get on up here, my colleague. I was in junior high when that rule. No, I wasn't.
I'm the one that suckered her into going in the water.
Okay, so can I give you a side story? I started out as a cleanup lawyer doing, cleanup law work under our toxics cleanup law. So cleanup sites and gas stations and huge sediment cleanups. And one day our agency, that is now my agency, issued like 400 or 500 water right decisions on one day that were all no's back in 1994, 5, 6. Tom comes walking in, he's the water resources section manager running all the water attorneys, but we're in the same group, but I'm not in his section. I'm a cleanup kind of contaminated waste attorney. And he walks in with about 25 cases. And sets them down. This is Southwest Washington. You're going to learn a little bit of water law. And then he assigned me the worst partner to help litigate the cases. I was a brand new attorney. He assigned our division chief, our boss, to help me. That was not very helpful at all. Jay Manning, who ended up going on to be the director of ecology that I am now. Great guy, just kind of teasing. But so long story short, it's Tom's fault that I got sucked into this incredibly wonderful, beautiful, challenging intense world of water law management. But I think that trust water right law went into law probably mid 2000?
No, it was actually on my sheet. It came in around 1991. And it came in kind of, I think, to follow what Oregon was doing at that time, which was really, if you are going to conserve water, and especially if the state's going to give you money to conserve water, that water should go into in-stream flow. But it would be protected from relinquishment. It's really expanded since then to the point where it's become like Maya said, a kind of a, we call it a parking lot, to let people who want to even go from alfalfa wheat to vineyards, which is happening, where they drop in acre feet, drastically. They won't worry about losing the water right. They can put that into the trust water right program, and it'll be protected from relinquishment under their terms. They put it under in a contract under their terms, and so they can use it for mitigation for something else. They can pull it out in a year or two. And basically what it ends up doing is, it ends up protecting their right, property right, which you would call it, like Maya said, but it also puts water in stream, because they rarely pull it back out. And if you're going to go into vineyards, you're going to stay in there for at least 30 years. So it's kind of a de facto in-stream flow enhancement.
Is there a time certain that I can pull it back out? Because I'm thinking about farmers who have bankers who say, you can't use your water right, your mortgage or your tractor.
You can,
You set out your terms, how many years that's going to last. And we've got in perpetuity trusts where people will say, forever, I love my river, I'm not going to use half of my water right the rest of my time here. I'm going to, in perpetuity, put it into trust to stay as an in-stream right, or others will set up a contract for being able to pull it out later in the future.
it comes down to whether you want temporary or permanent. And if it's permanent, it's usually, if the state paid for the conservation measures, let's say, it's permanent and you can't pull it out. It states them because they bought it, essentially.
Can you give me your statutory citation?
RCW,
9042.
that's it.
But 9038 was the first one with the Yakima Basin only, but 9042 took it over.
Yeah, so we set up kind of almost a pilot in the Yakima Basin to do trust water rights in RCW 90:38, and then we spread it out to have it a statewide program. So I'll just wrap up. Thank you so much. I'll be here to continue to engage with the panel and appreciate and understand the very difficult situation that you're in many times when you're trying to sort through why I've made a decision I've made, and really provide us the guidance that we need to, continue to run these programs day in and day out throughout our states. Thanks so much.
Okay, well, so Maya's made her decision, and here it comes. We know it's going to be litigated one way or another. It might be a rule challenge that goes directly to Superior Court. It might be a permit that the board that Tom and I and others here have sat on doing the trial work that goes to Superior Court. It might be a declaratory judgment action. It might be an appeal from a growth management hearings board, land use action, and it ends up in Judge Murphy's courtroom. And the question to her is, what does she do and how does she handle that, given 100 years of water law and all the complexity that you've just heard about and the drought? So Judge Murphy.
Should I come up?
No, you can, I think, can you all see the panel from, from over there? So, yeah.
Okay, I'll just stay here. So as Kathy indicated, at Superior Court, we get all kinds of different cases that involve water law. And as I think has been alluded to before, many of you know that as a general jurisdiction judge, I hear these types of cases regularly, but just as regularly as any other specific kind of case like an administrative appeal. I actually hear probably more tax cases than water cases. And that is in addition to criminal trials and civil trials and everything else, just to give you an indication. Last week I had a 4-day felony trial, child molestation case. That was my Monday through Thursday. On Friday I spent the entire day hearing motions. This week I had a 2-day contested mental illness commitment trial, jury trial, Monday and Tuesday. Did some other work on my motion calendar before driving over here yesterday, and tomorrow I will all day hear my civil motion calendar and an administrative appeal in the afternoon. So that's sort of how the weeks work for a Superior Court judge. I have no staff, I have no clerks, I have no one doing the reading other than myself. And I'm not saying that at all for you to feel sorry for me. I love my job. I don't want Maya's job. If anyone wonders, I do not want her job. We will not trade places. She does not want my job. I don't want her job. I love my job. And one of the things I love about it is learning about so many different areas of the law every week, sometimes every day, and learning from experts like many of you. And so it is actually a real pleasure to learn those things. But there are a few things that might make it a little bit easier. And when I say easier, I mean not just for me, but really for you. Because it's just as frustrating for me as it is for you when an appellate decision comes out and you read it and go, what were they thinking? And sometimes you're saying that about me. What were they thinking? And so I put together a bit of a tip sheet to help someone like me in the position of reviewing a decision that's addressed by a specific board that are specialists. The board that Kathy and Tom sat on, that you don't just get out of law school and get appointed to that board. The folks that are on those boards, and some of you are in the audience, are specialists in that area. You know what you're talking about. I'm one of those people at this conference that's intimidated by almost everybody else in the room. And so what I want to see is that expertise manifested in the decision, in the record, and then my attention drawn to that expertise. That helps me a lot. What I am reviewing, and this is true whether it's an appeal of a specific permit or an appeal of a rule, I'm looking at a record that often comes to me in a box. It's not tabbed, it's not in binders, it's just a whole bunch of records. And I'm hoping that the attorneys will draw my attention to the important records. When I'm looking at that box or those binders or whatever it is that is in front of me, I don't have them, here's one all highlighted or tabbed or with some red flags on them. So I rely on the attorneys to point out the very important parts to me. And in that respect, it's a lot like a trial. You could have a 4-day trial and the testimony comes out, but it's not like when you're hearing testimony and the dramatic music comes on, listen to this part, So I'm hoping to be drawn to that particular piece of evidence. Yes?
So it appears to me then that your reviews are on the record and they're not the known event.
So as I think Mr. McDonald indicated, it depends. So factual findings are often, if they're reviewed for whether there's substantial evidence in the record, depending on the type of case, but legal rulings are de novo. So, and that's why one of my tips is to make sure in your rulings you're clear as to whether it's a factual finding or a legal ruling, because often, depending on the type of case, the review may be different.
And then we'll relabel those anyway.
And for all of you know this, but for those of you who are judicial officers writing decisions, the defense of your decision depends on the attorney advocating for that decision. And so I run into this all the time when I see my decision being appealed, and I'm relying on the attorneys to make those arguments that I think I would make if I were defending my own decision, but I don't get to do that. And so what we do get to do is draft and sign as clear an order as we possibly can. What we relied on for those factual findings, because again, we don't know how the attorneys are going to argue it at the next stage up. So the best we can do is write a decision that's very clear. I relied on this testimony. I found this expert to be credible. I found this expert to be not credible on this point. That gets a different kind of review if it's a credibility finding than if I'm reviewing a legal conclusion de novo. So all of those things being clear in the decision help me know exactly how I'm going to review it. And these decisions are not easy, and I think all of us know that very, very smart people disagree as to how they are resolved, and that's true at every single level. We in Washington, I think, are very lucky to have our appellate judges who work very hard to try to come to the right decision, and very smart judges. And despite that, they disagree. And so this isn't just, very easy, oh, this is how we're going to decide these cases. It can be very complex legally and factually. And so I think one of the ways to make it easier for a court who's reviewing those decisions is to show your work. Show exactly what you did. We like experts and want to understand what experts say. Obviously, it's much easier to do that when it's plain talk, when there are acronyms that are explained rather than sort of speaking in a foreign language, and I'm sure that's true of all of you too. So these are really just basic tips as to how to make it easier at review at the next level, and how to preserve your decision as best you can at the next level, understanding that you're not going to be the one advocating for your decision. But you can make it easier by clarifying what was a finding of fact, what was a conclusion of law, what case did you rely on for that conclusion of law, what facts in the record. And if you're an adjudicative body that issues very simple decisions based upon the whole record, at least make it clear what that whole record was or is. Did it end at the time the hearing ended? So if I have the hearing transcript that I'm looking at, I can see that on January 16th, 2013, the hearing ended and everything stopped. What about all of these other things that got in the record later? Were they considered? Again, I want to know that, and I've had the situation where a lawyer in front of me can't answer that question. Now you could, but you're not there arguing to me. So again, what the lawyers have to argue with is that record. And if it can't be answered on the record, maybe the lawyer who's arguing to me is going to give an inaccurate answer. So you want to make sure that you make it clear the record is closed now, or the record is open. We expect that final arguments are going to be submitted, or some other things are going to be submitted, so that there's no confusion as to what exactly the record is. So, I did a tip sheet, but that's basically my recommendation is clarity in that decision-making process, so that at the next step it's clear.
Okay. Justice Stevens, the case then comes your way. A lot of water law cases, Judge Murphy, are headed to the Supreme Court. I assume that knowledge rests in you. Justice Stevens gets a different kind of record and a similar set of problems. So if you could speak from your perspective.
Yeah, so I found, I did not come to the Supreme Court with any background in water law. Probably my background is I'm a water rights holder, but that was it, an unadjudicated rights holder. But that's probably more common than not with appellate judges, and I'm sure that's not unique to Washington. The Greg Hobbses of the world, live in Greg Hobbs's home. And the rest of us, as I mentioned earlier, come to water law sort of indirectly. But let me comment that one first observation I'll make is many times, by the time a case reaches the Supreme Court, the issue may have less to do with the water law than with the procedure of how the case got there. So for example, in Tom's materials, you see the J.Z. Knight versus City of Yelm case. The appeal of that to the Supreme Court was solely on a question of standing. Very important question, who can complain about a decision surrounding water? Can someone who's an adjacent property owner, who has an interest in their own water use, have standing? And the court ultimately held there that the plaintiff did have standing. But the Superior Court's decision in that case on the merits was not before my court. And so once the standing issue could be determined, then the result below stood with the standing. So similarly, we get cases, I was interested in talking to some folks from other states. I get the sense that how cases percolate has a lot to do with how your departments of ecology or the equivalent address rulemaking. And our Department of Ecology has engaged in a lot of rulemaking that then gets challenged. So sometimes we see issues that arise out of a separation of powers doctrine issue, or if it's just a direct rulemaking coming up through the APA, that might be one path. We have a Land Use Petition Act. We have a Growth Management Act in Washington, probably many of your states do as well. And we have a statutory scheme for certain types of challenges to certain types of land use decisions. And based on a series of cases predating me, it became clear that in a lot of planning at the county level, water issues had to be accounted for. So sometimes we see really important water issues that come through a Land Use Petition Act, and we're not dealing with any kind of anything that your hearing boards, I guess those of you who are hearing examiners, would have touched. So I think it is important to think, let me put this in a more global perspective. When I became an appellate judge, I tried to conceptualize for myself, in my own judicial philosophy, what am I doing? What is my role? And the best description that came to my mind that I still adhere to is I believe appellate judges are like, our culture storytellers. It's our job to know the history, to know the stories, to repeat them and pass them down and to keep them relevant to modern times. So when we see a search and seizure issue, we've got to look at a whole couple hundred years of law and answer how does that apply to your privacy interest in your text messages on your smartphone. And I don't think it's different when we approach water issues. To me, what makes my job easier than I think your job or even your job is the standard of review. I'm not there to make a discretionary decision about what the best available science is going to show me ought to be the mitigation approach in this situation. My job is just to look at the traditions, look at the framework, and assess the narrower question. And so understanding that, and I think that's a pretty consistent philosophy that a lot of appellate judges have. I mean, when my kids were younger and at home, I used to joke that I get to be mom at home. Don't come looking to the judge to be mom and figure out all your problem, to tell you who gets what in that way. That's not really our role. And I think when we assume that role or arrogate ourselves to that role, we make our biggest mistakes because we should be taking the long view. So the thing I guess I would emphasize does have to do with the clarity of what parts of your decision are based on what. So if you're exercising your discretion and you're making a determination, those words ought to be crystal clear in the findings. I'm a big believer in what someone once described as the haiku approach or the single stanza approach to findings and conclusions. Single subject per paragraph. I was joking that you can call them findings of fact and conclusions of law, but we know a conclusion of law when we see one, typically, and so sometimes we'll move it over. But nonetheless, the clarity about, based on this is my discretionary decision. Based on the statute, this is what the statute holds. That's going to be de novo review, right? So we know when you're interpreting the statute, and if that interpretation is mistaken, we'll call that out. But without that clarity, I agree that the people who are going to be arguing this case on appeal, and certainly by the time it gets to the Supreme Court, aren't as familiar with your world, and certainly not with your record, and problems will occur. We have a rule in our court rules pertaining to summary judgment in general civil cases, which requires that that the order should designate everything brought to the trial court's attention. And so whether that's before or brought in after, and that all of those items have to be designated in the record on appeal. Even if the trial court had ruled something was inadmissible, it's still got to be in the record. I think that there is no similar rule that I'm aware of that pertains to how we get decisions when they come up through the APA. But wouldn't that be a great thing for you to do? That your order ought to list every item. Make the parties provide that to you. In seriatim, everything you looked at, whether it came in before you heard oral argument or after, and then we can have an idea of whether something seems to be missing.
And let me ask a question that's related to this, and it deals with something Rachel Pascal Osborne said last night, and certainly I saw on the board when Tom and I were on it together, is you have a hearing or you have a trial in Superior Court or the contested hearing before the board I'm on, and you have experts, and they are all credible. They are from the University of Washington, they're from the University of California, they've modeled, their models all reach different conclusions, and they are really good and convincing, and you have to sort through that in hydrogeology or all kinds of complex science. Sometimes I said it was like being in graduate school all day listening to expert witnesses. Let's start with Tom and talk a little bit about that aspect of it. How do you sort through that scientific evidence in a water case, and then what do you do with it? How do you present your decision when you have to, in the end, say this model's better than that model, or that we believe this expert and this one got taken apart a little bit on cross-examination, maybe? What do you do, Tom?
Well, you kind of said a few of the things. It is difficult when you have some competing experts who are credible, but they have different. They have different conclusions. And really, a lot of times, as I'm sure all the judges know, it comes to how they, maybe on cross-examination, how they came across, what they actually relied on. It becomes, one of the things we have to our advantage, I think, at the PCHB is that a lot of times one of the experts is going to be supporting the agency's decision. And the Supreme Court has held that we are to give deference, some level of deference, not too much.
We always kid Maya's middle name was deference.
My middle initial is D, and so
That's
I'm
true.
saying Maya Deference Bellin.
Yes.
But I don't always get it.
We've had some good discussions.
I think those say we're appropriate.
That's where, but and we've run into that where we've had experts doing experts. They're all good, but and ecology has had their experts, and the permit holders had their experts, and the people challenging it. And some of these experts we see quite often, and some of them are obviously newer, which is we now because I'm not on board anymore. But I find that we have two tools. One of them is that the deference issue comes up. We also have the ability, being on the board, and to ask questions. So when I was there, it happened quite often, especially with experts, to try to understand exactly what they're saying, because a lot of times I didn't quite understand what they were trying to say. The other thing is that on the experts, I think it's the material in their report. If their report is well written and understandable, it really helps. And if it helps, then you kind of want to give them deference because you can understand it better. And some of the reports aren't as good. So those experts really are going to be ones that are testify well, write well, their attorneys present them in good light, and then like I said, to the extent that we have the ability to give deference, we will look at that. So I don't know if that
Judge
answers-
Murphy?
I just want to follow up on these comments because I agree wholeheartedly. And I see some nods in the room. Have any of you had that situation where you have an expert in front of you that you know is really good? You've heard them before, they're really great. But on this particular case, what they presented to you, you just kind of you don't understand it? Anybody have that happen before? Yeah, so I see some nods. And it calls to mind for me some of the pattern jury instructions on expert witness testimony. Some of those things you consider. You consider, what was the basis of that testimony? What did they consider in coming to their conclusions? Is it consistent with other expert or lay testimony in the case? How does it fit with all of the other findings that you're making or with the other testimony of the other witnesses? How did that person do on cross-examination? How clear is their opinion? How specific is their opinion? Is it a general opinion that is generally accepted but doesn't necessarily help you resolve this particular case? Those are all the kinds of things that are helpful for you to not just consider in deciding the case, but also to show your work and put it in your order so that you're telling me, when I'm looking at pieces of paper, what you did in finding this finding instead of this other finding, especially when both are credible. Both experts are credible, both are experts in their area, and they know that particular area, but there are very subtle differences that make the difference in the case in finding one over the other. Yes?
I guess I'm wondering how you're using the term credible. Because credibility a lot of times, in a lot of different cases has to do with sometimes the honesty of whatever's being presented. But it seems to me that credibility goes more than that. And some of the things you're talking about having to do with the accuracy of the history of the information going in. And it seems to me that that's part of the credibility determination. And many times you get down to a point where, without criticizing the person, there are fractures in the foundation of their opinion. And I think that's credibility.
Exactly. And maybe you don't want to say that, again, because this is an expert that you see on a regular basis, and these are people who testify on a regular basis generally in this area, but you are going to have to be making those decisions between two people who are in that category. And so it is helpful to show those kinds of factors that Mr. McDonald indicated, when considering what went into this opinion. They had this report. This expert didn't have that report. This expert, while their findings are generally true, are not specific enough and don't take into account this other expert or lay testimony that we've heard in this case. That specific kind of information is helpful when it gets to the next level.
And I think that's really a good point, because I think we have been bitten, or were bitten on the administrative board by making specific findings that someone was credible, and then you hear that forever, that witness is credible or that witness isn't credible, when in the next case they are wholly credible and have a better position.
Well, it just seems like it's the wrong label, because
the wrong
especially
label.
when you're looking at modeling, you want to know the assumptions, the parameters that went into the model, the validity of the data. I find this, from a judge's perspective, and of course it's not unique here, we deal with this in so many areas. One unique thing about an environmental case is, certainly true under like the Environmental Species Act in federal cases, is sometimes the law of what you're supposed to be looking for doesn't make any sense to the real scientist. Like, we would never even ask that question. So sometimes you're getting experts having to talk about something that doesn't make any sense to them either. So to me, rather, credibility, it's one thing when you're talking about a he said, she said kind of determination, but you should be calling out, what were the parameters on the model, what were the assumptions on the model, what was, how did they quantify their uncertainty? Because oftentimes what we'll see is some report that comes up and you see the expert quantifying uncertainty and there's some margins, and then you get this number, and we should all look twice at that number. But of course what terrifies me the most is we have no background in this. right? Do you get fried Albert challenges at the hearings board? I would assume. And, you know, we review those de novo. That's terrifying, too, with no background. So I mentioned I'm involved in this National Science Courts Institute. One of the things we try to do is get judges to get training on statistical analysis and modeling. And I know some of you are from New Mexico, and I don't know if you've had a chance to do the fairly recent program Los Alamos is developing. I had a chance to go to that this summer, but it scared me that at the end of the week, and this was a cohort of judges who'd had a lot of science training. We did a fracking scenario. We got some good things. You know, we cross-examined the experts and we picked out a lot of flaws, but all of us missed the fact that if you looked at the modeling, the plaintiff's experts' model would always leak methane, and the defense experts' model would never leak methane. And, you know, we missed that. So there it is.
And Justice Stevens, do you have, oh, okay, first, question.
And sometimes what I find competing experts is that the truth lies somewhere in between.
They're both
It's really not
experts.
an issue of credibility. They're both credible experts. And it's somewhere in between, and in the decision, it's setting forth in your writing that this is why the truth lies somewhere in between. Isn't that?
And I think that where that comes in, and it comes in many, many cases, is as a finder of fact, you are weighing that evidence along with all of the other evidence. And so it may be something that is not exactly either one of those competing experts or a third expert, but there may be several other witnesses or a lay witness that actually puts it in better perspective for you as the finder of fact. And that's, again, I just say, show your work, because it may be one of those situations where you have experts, as Justice Stevens described, this one's always going to find this way, this one's always going to find this way. Let's put this in perspective of the whole case and all of the testimony and all of the evidence in the case, and you may find something different than any of the experts.
You know, a lot of this is just heuristics or rules of thumb that lawyers use to decide something they don't know the answer. I mean, that's really what
That's
it is.
really true.
And that particularly in complicated science. And I think we got to be careful using the word truth. I just don't know with that. It's probabilities, it's uncertainties. We have to think in a different way. In science. And goes back to your point about science and law. Awesome.
Other question here?
Well, one of the issues that I think arises though in this is if you have these two competing positions and you try to find something in the middle, there's really no expert to support that middle position.
That's right.
And so you're taking the place of the experts. That's very difficult.
Right, and that's probably, that might not have a reason to stand when it's being reviewed, right? So, yeah, I mean, again, it's helpful, as all of you know, it's helpful to know what the review is at the next level for every one of your findings and conclusions, and really think about that when you're going to take that step, because it may be the right thing at that level, but think about the next level and who's going to be looking at that. And, you know, just picking, you know, I think it should be here when there's no expert testimony to support that, that's going to be tough.
Before, I want to shift gears here a little. Oh,
Can I do one
sure,
quick?
Susan.
Going to Maya discretionary level.
Yes.
She's at the administrative level. She's at the level where that discretion and weighing that kind of evidence gets some deference. Shouldn't someone at that level of a hearing officer, I'm assuming of a hearing officer?
No, they
So the
don't.
way it works in our state is there are board members in this room, so if the ELUL board members raise your hands up. They are not within, they are a separate arm of state government and are not within my agency. So some agencies in Washington have in-house adjudicative proceedings. Department of Ecology specifically does not have that because we're so trusted by our legislature in making these water right decisions. So there's a separate arm of the state government, it's a separate agency that's independent of my agency that all of my appeals go to. And so,
In other states that do have that hearing process at the administrative level, I think they probably can kind of weigh that evidence
Well, there's a deference to the agency.
As the underlying decision maker. And so that's when I hope that if there is that kind of schism between two experts, two models, how they're applying, what those analyses are, that in that middle part is that applying the policy issue of the underlying law in which I'm trying to implement, and then trying to balance it out in that regard. And that, I think, does happen at the appellate levels. It happens in front of our boards who are having to look at and apply the law and the policy ultimately to those facts, and then it goes up through our appellate process.
Question?
Follow up?
Sure.
I'm not sure I understand. So you make a decision without a hearing, and then if somebody doesn't like it, then it gets appealed above you?
Yes.
Even though you were party to that hearing?
Yes, I'm a defendant. So I'm a defendant on my appeals, or a respondent.
So even if you have, right, you have two parties, you don't even know if there's another party out there that's going to object to your decision, is that?
Generally, we know, we do have a public hearing and comment period. We have people that have a time frame to file objections when we're in the middle of our decision-making. It's kind of very transparent. We put our draft decisions on the internet. People can then file objections, but sometimes you do not, in our state, you do not have to have filed an objection and publicly let your concerns be known, available. And you just wait you have a 30-day appeal period from the day I make my decision. It can be appealed to the board here in our state, and it can be anyone, anytime. It can be,
new issue.
yeah, and new issues brought, entirely new issues.
Anyone with
So is it
standing.
usually the applicant, the department, and the objectors?
In terms of the parties to the case? Yes, so it's the applicant. If I issue a no on a request that they've asked for to have water, they can appeal, and then sometimes a tribe or an environmental group will intervene on the state's behalf to say the state got it right. Or if I approve a water use and more water out of a stream and there's concerns, sometimes it is a neighbor that says, I don't think the state got it right. I'm worried my well or my water right might go dry, and so I'm appealing Ecology's decision. So then I stand with the applicant and we defend the case together.
And I think it's important to know that when it gets appealed, it's not any kind of record review by PCHB. It's a de novo hearing, and any information or evidence can come forward in the hearing that wasn't available to Ecology when they made their decision. So sometimes the board will have before it a permit decision that all of a sudden the evidence coming in supporting or not supporting that decision was evidence Ecology never saw before. So the board may be reversing the decision based on evidence Ecology is like, well, if we would have known, we would have done something different, but it's totally separate agencies.
Can I ask, that's not unique to Washington, is it? Does that happen in other states?
I wanted to ask a different kind of question now, and this is less on judicial review and goes back to what Maya was talking about. And I have to be careful here because we had a Supreme Court decision last week that relates to this issue, and the reconsideration period is still pending, so we can't talk specifically, and Justice Stevens can't talk specifically about the issue. But the bigger issue is, and you heard last night, we have in-stream flows. You heard Maya talk about it, in-stream flow newly set for the Spokane River. Over the last several years, Ecology has had multiple efforts to try to work within those in-stream flows. In one case, they attempted to modify the in-stream flows up in the Skagit through a rulemaking process that resulted in the Swinomish case that Judge Murphy handled at the Superior Court level because it was a rule challenge, and that case went to the state Supreme Court. We had a case over in eastern Washington involving in-stream flows on the Columbia River where there was an effort to make some payment of money for habitat improvement that would allow for a water right and affect in-stream flows, and that was at the board level. And we had this recent case that was decided by the Supreme Court involving a multi-jurisdictional effort to get some more water for population growth, and it affected in-stream flows in the Nisqually River and Deschutes River in western Washington. So that's the problem Maya's trying to Ms. Bellin, Director Bellin, is trying to deal with, Maya Deference Bellin is trying to deal with. And it's a big one. And in other states, it might be called something else. In Washington, we're calling it mitigation. And the issue is mitigation. Can you mitigate for that depletion of the in-stream flow that's been set by rule by putting wet water, real water back into a river, or by some alternate out-of-kind mitigation that might be habitat improvement? And I've talked to Justice Hobbs about this last year. I think in Colorado it's called something else, and I don't recall what. But and I don't want to put anybody on the spot here, but can we talk a little bit about this? And Tom, maybe I'll start with you, what your thoughts are on where are we headed in terms of ecology's ability. Is this the issue of the future, or has the issue been put to bed?
Well, I don't want to get into a situation where we're talking about this case yet, since it's in the period of motion reconsideration, but and it deals with an element of the in-stream flow laws that we don't have to deal with here, because I think your question, and I'm going to take your question as, we have a situation where we're trying to protect the in-stream flows in the state. That process we're trying to do through basin management plans, and in those basin management plans, ecology promulgates, an in-stream flow level of quantity as to what they think should be protected, like they did in Spokane. The basis of that flow, though, is, I should say though, the basis of that flow is the language in two different statutes that we have, 9022 and 9054. And 9054 basically says we want to protect flows, minimum flows for the in-stream flow resources, fish, aesthetics, water quality, recreation. We want to do that. So that's what we're trying to protect by these in-stream flows. Well, that then is, okay, we now have competing interests, obviously, in terms of trying to take water out and trying to have water available for other uses. So we have the in-stream flows and the policy behind those under 9054. We have obviously the reserved water rights and the time immemorial water rights for the tribes and other federal reserved water rights that are in-stream flow. And then we have the competing interests. And so where do we go with that? One of the ideas has been, and I think Maya Bellin would agree, is can we create an opportunity to satisfy the core reason for these minimum flows, which is protection of fish and recreation and quality? Can we do it through a process other than a minimum quantity? Because sometimes that minimum quantity doesn't make sense anyway. I mean, if you're behind a dam and you say we need 30,000 CFS going through the Columbia River, but it's not moving anywhere. So can we come up with a different type of process to protect those in-stream flow resources? And we know in that area it's water pollution or it's temperature. So with Fish and Wildlife, with the tribes, with people that are really interested, with environmental groups, and with a lot of the farmers and irrigators in Eastern Washington are right on board with this. Let's put together some type of mitigation process to address that. Well, it's flying in the face of this quantity that is in the rule that is considered an appropriation. And where do we go with that? I think it's going to be in the face of the legislature. I think it's going to be in the face of the Department of Ecology, some real difficult issues as to what to do with those rules. And I think even with the decisions that have been by the Supreme Court, I think there's still some openings to say there's some flexibility in applying the implied law.
And the Supreme Court's couple of decisions have said ecology do not have the authority to freely reallocate water in this state. So that's the box. So Maya?
What I think I do have the very clear authority to do is to do what we call water for water mitigation. So if a water right holder has this chunk of water and they are only going to use 3/4 of it, that next quarter can go to a potential new use, even if we've closed that basin and said no new water comes out of the Nisqually River or the Deschutes River, or let's just pick something over here on the west side, Beaver Creek in the Methow. A quarter of that water will no longer be used by that water right holder, and so someone else in line might be able to buy that water or be able to say, I'm going to offset my uses by overlaying that senior water right onto my needs to show that there's no net increase or no net impact to the river system, which is our impairment standard, right? You can't change or transfer a water right or issue a new one that will impair either the in-stream flow or senior water right holders. So if we can prove, whether through that's modeling on hydraulic continuity, if it's a groundwater right, if we can subtract the non-consumptive part of the potential new use to say, you know, they might be pulling 10 CFS out of the river, but only 9 of it will be, only 1 of it will be consumptively used, the other 9 will go back to the system. And if they can find water for mitigation to get that 1, then we can maybe have a discussion. If we start getting around the edges of, man, oh man, wouldn't it be great to stop the diking and draining of the wetland area in this situation that's causing huge problems for the fish habitat in that river? Wouldn't it be great if we could do better forest management and not have a bad forest management process that brings a ton of silt and sand and problems down into this river system? Wouldn't it be great if we could pull back a hardened river or a hardening of a river edge that just makes it just a speed right through and that water can't cool in terms of a bulkheading situation? Those are things that we really are thinking about from a restoration standpoint, but in the water code, getting credit for that in some of these complex water negotiations is not fitting the bill in terms of proving that we are honoring the water code's no impairment requirement. So this is, you know, like I said, I think the foundation at minimum, if we can prove there is no net impact to the senior water right holder or to the in-stream flow, then we've got flexibility. But if we try to say, well, there might be a little hit, but it's during this time of year, and that's maybe we're not as concerned about salmon that time of year. If we have closed that river, we're in a thimble. We're in a pretty narrow place.
Okay. Any
Can
other
I comment just more
comments? Sure.
globally about,
Yes.
just an observation that I think should be quite obvious, that a lot of water laws in Washington and other states, and law, I'll just talk about the statutes, are written with a particular scientific basis in mind. So maybe they had their expert who they found credible, and that's what wrote the statute. And so, and this isn't unique to this area of law. So a lot of times we see things where you've got a framework that you have to work within, and then you're trying to deal with the evolution of understanding, with, you know, just things as they emerge. And so my observation just more globally is, you know, when I talk about appellate judges having to take the long view, you know, clearly the legislature keeps moving too. And so there are just a lot of moving parts. And, you know, I think we're going to see more and more of these kind of cases. I will comment that I find it interesting when I just take a step back and think other parallel areas of the law where the legislature used to be super active, and then they kind of pulled back and maybe did more of a framework and let things happen at areas where they could be a little more nimble. I can think of a dozen places where that has happened, where there's just been some backing off of precise legislation so that you could be a little more nimble. I haven't seen that being really advocated as a way to approach evolution, you know, as we enter this new era. So,
I have a question for you on that. What role do you think the Supreme Court has in decisions where they say, this happened in what is called the Seeking Creek case, Rutkowski, where they say, we think this is what the statutes are, and this is how we're interpreting them, and we're obviously correctly interpreting them, but we don't think this should be, we think there's an issue here, there's a problem, to say something in the opinion, to say, we think the legislature should be addressing this.
you know, I mean, there are no rules against dicta, right? I mean, courts can there's good dicta and there's bad dicta, but I think there's kind of a culture against thinking we know. You know, so I think most justices, appellate judges, are comfortable saying, we're going to interpret this piece. And like I said, I play mom at home, Tom, you know, go talk to, go figure it out. You know, but my question, you know, the question in front of my court is, does this statute allow this to happen? That's the question.
Okay, do we have time for a couple of questions, Alf, and then we'll wrap up this panel. So, John.
I'm aware that I guess between 2002 and 2004 there was a study of a permanent water court he had the support of the State Judicial Council, but didn't proceed. 10 years later, is that still a viable idea? Is there any possibility of coming to fruition?
I would just tell you frankly, without the level of adjudication happening, it might be a difficult budget allowance that our legislature would provide. I mean, they'd want to know how many cases here are going to be heard, and if we had some of the activities like we're having in Idaho.
And that's what is the prospect of moving forward with adjudications? There are user drought, climate migration,
Yeah.
California, in-stream flows, common law, riparian rights.
Yeah.
That's a job that must have to do.
Yeah, and hearing Mr. McDonald say that
So what, is there any and to add that on top of all that, the neighboring states adjudicating Washington's water rights, and then start another adjudication on the Police River Basin.
in Walla Walla.
In Moscow, Oklahoma.
Mhm.
And so.
We've got Oregon and Idaho.
Is there, yeah, and we'll be adjudicating some of Washington's water rights there too.
Yeah.
Moving forward with
So it's a matter of funds. And right now, with our very drastic cut in our general fund, on top of that, I run 10 environmental programs for the agency, everything from the Hanford nuclear waste cleanup to our regular cleanup sites, our air program, all of those things. Our main fund that we rely on that's not general fund from the state is a Model Toxics Control Act account, which is based on the value of a barrel of oil. And right now that's down, that's plummeted. So we just see these fluctuations. So without a dedicated need, the legislature is going to shy away from giving us funds to be able to adjudicate the Spokane. But if we moved into an adjudication mode to get to the rest of this, 90% or what'll it be, 80% of the state, then I think a water court would make a lot of sense, and I would welcome you all to come here and be practitioners for our work. But with the cases that come up, there are water cases, but we're not talking, there's not 100 pending cases right now or 200 pending water cases right now at our appellate or Superior Court level. So I just don't know if we could prove that we would need that resource at this point in time. But if we were in adjudication mode, I think I would be very happy to see some expert court at a Superior Court level that right now only has the authority to adjudicate our water rights be established, so we could have that expertise and run through those quicker than being in a regular Superior Court case where Judge Murphy has said she's dealing with a criminal issue to a family law issue, to a motion court hearing every week.
Right, and the other thing you didn't mention is, and we don't have a permanent water court, but I handle all of the administrative appeals that come from the Department of Water Resource go to my court. And we're dealing with some really tough administrative issues. We have conjunctive management, dealing with the Idaho's conjunctive management rules. So having, and they're very complex cases, there are a lot of issues of first impression. If you have these issues being decided in all these different venues, you just have a lack of certainty. Water users would have a lack of certainty. At least they know it's all coming through one.
Yeah,
and then it goes up, and then it goes up. And the other problem is that they're all coming through piecemeal. And so it's also important to educate the health board as well, so that you're not having unintended consequences. Because sometimes when you're in critically existing law that are first impression, the answer may seem obvious on its face, but when you get down the road, you have to apply it to some other principle. I would see that.
Right, so luckily it's not that piecemeal because all of my water permitting decision appeals go to our Environmental Hearings Board. And that's a board of our experts that understand that area. It's then they get appealed up to the Superior Courts and then make their way back to the Consolidated Court of Appeals in Washington Supreme Court. So all those are there. Adjudications, though, happen in our individual counties.
Any other questions? Alf is wanting us to wrap up. One more question.
From my on how the trust works, to make sure I understand, you said somebody who's not using the 50 acres, they didn't want to get enforced for abandonment, they could say, I'm going to put that into the trust, and then it would just stay there.
Yes, that's.
So
They sign a contract and they say, we make sure their water right is wet water. We make sure they're not trying to put into trust water that was relinquished or abandoned 50 years ago. So we go through a process to determine that it's wet water that has been used. And
Not
it's
all the time.
Shush. Generally, depending on the criteria. And then that portion goes into this parking lot to either be pulled out later if that farmer or the user needs it, or to stay in perpetuity for the benefit of in-stream flows or some other purpose.
Okay,
We're an exception to that, which is really the pure parking lot, is that you can donate your water to the trust temporarily for the quantity of water you've used in the last 5 years. And ecology will put it into the trust. They won't protect it as an in-stream flow because they haven't determined whether it is
It's wet
valid.
water.
Because before the 5-year period, if you've used it within the last 5 years, you may have relinquished it.
Right.
So they allow these really quick movements into trust, just to park it there, and even though they haven't done an extended validity analysis of the water.
okay, we've had a very energetic, very esteemed panel here, so let's thank them.